My name's Deputy Inspector General of Police, Dr. Shehu, PSC. To talk about PRAWA, Prisoners Rehabilitation and Welfare Action, we have a very, very good rapport, good understanding, and good synergy between the police and PRAWA for many years. It is an institution that concerns primarily on respect of dignity and human rights, which the police are supposed to be part of it. And also capacity building to the police to enable them to perform effectively and efficiently in conjunction with the fundamental respect to the fundamental human rights as enshrined into the Nigerian constitutions of 1999. It's very, very beneficial, and at the same time in building capacity and enabling the police officers to perform credibly when they go out to discharge their duties. The police is an organization that deals with all kinds of human beings. When they come across a police officer, they deserve to be respected by police in ensuring not only their security and safety, but also in respecting their dignity and human rights. So in a nutshell, the training and retraining we are getting from the PRAWA is to enable us have police that will function and discharge their duties in a most standard and acceptable manner by members of the public. At this juncture, I want to say kudos. Welcome to the Nigeria Police Force online training.
I want to welcome you yet to another module in our series dealing with the course Guidelines for Selected Police Interventions. Today we are dealing with Module 7, and Module 7 deals with police arrests. This is a topic that everyone should be interested in. I'm sure that you are interested in it and should indeed be interested in it. So let's first start by looking at our lesson objective for today. Our lesson objectives is really to promote greater understanding of the application of human rights in terms of the execution of police arrest. And secondly, in terms of our expected outcome, we expect that you, after this course, will be able to exhibit greater knowledge in relation to the guidelines for good practices as it really concerns exercise of police arrest. Okay? Now, what is arrest? What is arrest? The Concise Dictionary says that it is to deprive a person of liberty by taking him or her into custody, especially by a lawful authority. So you are depriving a person his or her liberty, or then taking the person into custody. Okay? So that is one definition. But however, the Black Law Dictionary states it like this. It says, it's taking or keeping of a person in custody by legal authority, especially in response to criminal charge. In response to criminal charge. So you can see the similarity between the two definitions given by the Concise Dictionary and by the Black Law Dictionary. Now let's look at Section 3 of the Criminal Procedure Act, CPA, this Section 3 of the CPA. It indicates that an arrest is effected by the person making the arrest by actually touching or confining the body of the person arrested, unless there is submission to the custody by the word of mouth or action or conduct. What is he saying here? He's saying that you can effect arrest by actually touching the body of the person being arrested. However, they can also verbally indicate it. Now, let's look at some of the principles that, human rights principles that should guide our behavior as police officers in relation to arrest. The first document I want to bring to our mind is the Adversarial Declaration of Human Rights, the UDHR. Now, in the UDHR, I want us to look specifically at Article 3 as well as Article 9. Article 3 says that everyone has the right to life, liberty, and security of person. Whereas Article 9 says no one shall be subjected to arbitrary arrest, detention, or exile. Now, bear that in mind as we then move on to look at also the International Covenant on Civil and Political Rights. And in this regard, I'm also bringing to your mind Article 9 of the ICCPR. And what does Article 9 say? It says everyone has a right to liberty and security of persons. No one shall be subjected to arbitrary arrest or detention. No one shall be deprived of his liberty except on such grounds, that is according to such procedures that has been established by law. Anyone who is arrested shall be informed at the time of arrest of the reason for his or her arrest and shall be promptly informed of any charge against him. So if you look at, let's go back to that. Article 9, part of Article 9 of the International Covenant on Civil and Political Rights uses the same language that reminds you of what you saw in Articles 3 and Article 9 of the Universal Declaration of Human Rights. But it went beyond that to say, okay, first, everybody have the right to liberty and security of persons. That's established. Everybody has the right to be free from arbitrary arrest and detention. Okay? But then he now says that there are grounds when this will not be the case. But in those times, you must follow due process. The due procedure must be applied. And then he goes on to say, when indeed you have effected this arrest, as part of this procedure, one of the things you must do is to tell the person you are arresting why you are doing so. Secondly, you will tell the person whether there is a charge that you are bringing before against them. So please remember what we just discussed now. Let's go on. Now, I also would like us to look at the body of principles for the protection of all persons under any form of detention or imprisonment. The principles I would like us to look at in that body of principles includes Principle 2, and then I also would like us to look at Principle 9. Now, under Principle 2, it's saying that arrest, detention, or imprisonment shall only be carried out strictly in accordance with the provisions of the law and by competent officials or persons authorized for that purpose. I would also like us to look at the provisions that are contained in the Administration of Criminal Justice Act of 2015 to see some of the things that have been highlighted as the procedures. Okay? So this is very, very important. It's very, very important. And also we need to look at what are the duration, what is the time frame that is, and the time limits that are being granted. Now, let's again look at our Principle 9. The Principle 9 says that authorities which arrest a person, keep him under detention or investigation as the case may be, shall exercise only the powers granted to them under the law. And they shall exercise, in such a way that these things should not confuse us. We need to clearly understand what are those procedures that are provided to the law. Anyone who is arrested shall be informed at the time of the arrest of the reason. We've said that. We've talked about the issue of charges, and there are many. So as a police officer, you need to take time to go through this. Yes. Now, to the Constitution, which is actually our ground norm. The Constitution of the Federal Republic of Nigeria 1999 as amended have clear provisions that I believe it is so critical to every one of the police officers that are attending this course today, and indeed for every officer, police officer, and other law enforcement agencies, that actually they need to understand to be able to carry out this in the discharge of arrest, of this function of arrest. First is Section 35, sub 1 of the Constitution. What does it say? It says that every person shall be entitled to his personal liberty, and no one shall be deprived of such liberty, except in the cases and in accordance with a procedure that has been permitted by law. Then he goes on to say, in the execution of the sentence or order of a court in respect of a criminal offense in which he has been found guilty. That is the only time, one of the instances where these power rights would be restricted. The other point is that by reason of his or her failure to comply with the order of a court in respect of a criminal offense in which he has been found guilty. So these are the exceptions to sections 35 sub 1. Now, for the purpose of bringing him or her before a court in the execution of the order of the court, or upon reasonable suspicion of having committed a criminal offense, or to such extent as may be reasonably necessary to prevent his or her committing a criminal offense. Then he goes on to give you a further one. He says, in the case of a person who has not attained the age of 18 for the purpose of his education or welfare. Then he continues. He says, in the case of a person suffering from infectious or contagious diseases, persons of unsound mind, persons addicted to drugs or alcohol or vagrants, for the purposes of their care or treatment or the protection of the community. And then he talks about for the purpose of preventing the unlawful entry of a person into Nigeria, or of effecting the expulsion or extradition or other lawful removal from Nigeria of any person, or taking proceedings relating thereto. I also want us to bear in mind that if you look at the one relating to the case of a person suffering from infectious diseases and contagious diseases, this is actually, we can understand this in the remit of what we've just been experiencing in terms of COVID, and on what point people can now be said, okay, you cannot move here or you can move here and all that. So it's important to understand what those restrictions are. Now, please also note the following. Provided that a person who is charged with an offense and who has been detained in lawful custody awaiting trial shall not continue to be kept in such detention for a period longer than the maximum period of imprisonment prescribed in the for the offense. Also, any person who is arrested or detained shall have the right to remain silent or avoid answering any question until after consultation with a legal practitioner or any person of his own choice. A person who is arrested and detained shall be informed in writing within 24 hours and in a language that he understands of the facts and grounds for his arrest or detention. So if you look at some of these ones we have been talking about, you can see a whole lot of things. The right to remain silent, for example. And then I will ask, if you arrest somebody and then you take the matter to the person to the station, and then you're asking the person and you say, no, I must talk to you until my lawyer comes. What is your response as a police officer? Do you begin to inflict torture, or do you indeed know that the person is entitled to their lawyer? And in saying this, it is important to see what is it that the Constitution has said. Also, what is it that the Legal Aid Act of 2011 have said in terms of persons who are detained having access to a lawyer and the right to be able to have a lawyer. And if they can't pay for one, that the state should be able to provide that. Now, I also want to mention the following, and this is to say that any person who is arrested or detained in accordance with the subsection 1C of this section which we have read, that there are certain things that needs to be noted, that this person should be brought before a court within a reasonable time. And if he is not tried within a reasonable time, note this following. A, 2 months from the date of arrest or detention in the case of a person who is in custody. This is now telling us what that reasonable time is. So it says 2 months from the date of arrest or detention in case of a person who is in custody or is not entitled to a bail, or 3 months from the date of arrest or detention in case of a person who has been released on bail. He shall, without prejudice, without prejudice to any other proceeding that may be brought against him, be released either unconditionally or upon such conditions as are reasonably necessary to ensure that he appears for the trial at a later stage. You note there are 3 things I would like us to note. We note the issue relating to those who are in detention, that we are given 2 months period. The issue about 3 months, those who have been released on bail, either conditionally or unconditionally. Now, we're going to talk more about the issue about the 24 hours, maximum 48 hours reduced, 48 hours that needs to be given depending on the location. So let's be specific. Let's still look at subsection 5. It says in subsection 4 of this section, the expression reasonable time means A, in the case of arrest or detention in any place where there is a court of competent jurisdiction within a radius of 40 kilometers, a period of 1 day, that is 24 hours. That is between the time you have arrested the person and the time you present the person to the court. A period of 24 hours. And B, in any other case, a period of 2 days, 48 hours, or such longer period as in the circumstances may be considered by the court to be reasonable. So this is important. So the question therefore is that when you arrest, are you considering the requirement of 24 hours or maximum 48 hours between the time that you arrested the person and the time you took the person to a court? Also, look at the circumstances whereby this applies and when this is not applying. So if you ask yourself, of the people you are arresting, how many really are you ready to go to court within 24 hours or within 48 hours? Now, let's look at the subsection 6. It says, any person who is unlawfully arrested or detained shall be entitled to compensation and public apology from the appropriate authority or person. And in this subsection, the appropriate authority or person means an authority or person specified by law. Okay? Now, we also continue to look at some of the things that have also been stated. So let's look at this subsection 7. It says here that nothing in this section shall be construed as A, in relation to subsection 4 of this section. Remember subsection 4 in terms of the reasonableness. In relation to subsection 4 of this section, as applying in the case of a person arrested or detained upon reasonable suspicion of having committed a capital offense. And B, as invalidating any law by reason only that it authorizes the detention of a period not exceeding 3 months of a member of the armed forces of the Federation or member of the Nigerian police force in execution of a sentence that has been imposed by an officer of the armed forces of an offense punishable by such detention of which he has been found guilty. Now, the point I want to make here is, remember, look at the proviso to the point we made in relation to capital offenses. And I know that in the field there are times that persons who have committed offenses that are not capital offenses are actually charged for capital offenses. So either for different reasons, including the fact that you know as an officer that you could not meet the requirement of 24 hours or 48 hours. So, but this is not good. So what we are encouraging you here is to be able to have a clear guide in terms of what you do out there in the field. You have to understand. If the person you have arrested, the question is that, are you ready to be able to go to court or charge that person to court within 24 hours or 48 hours? And if the answer is no, does this person actually get covered by those recommendations that or issues that we mentioned? So, for example, is this person that is charged for a capital offense? And if the answer is no, why are you then doing it? So part of the explanation around this or resolution around this could be for us or for police officers to be more involved in ensuring that you do your proper investigations. You are ready with your facts, ready so that by the time you arrest, you are ready to go to the court. This is important. So let's look at quickly what are the types of arrests. We can have arrests with warrants. So for this, look at Section 25, Section 26, Section 27, as well as Section 58, Sub 1 of the CPC. Also take time to look at Section 422, 419 of the Criminal Code, as well as Section 4 of the Administration of Criminal Justice Act of 2015. Remember that the warrant of arrest is an authority in writing by a court, which is given to a police officer or any other person, and which empowers the person to what? Arrest as suspect or arrest an offender. See also Section 25, Section 26, and Section 27 and 28, 58 rather, Sub 1 of the CPC. A warrant of arrest may be issued following a complaint made before the court. However, the complaint must be in writing and on oath. A warrant of arrest is applied for where the allegation against the offender is a serious one and where a summons is disobeyed. Also, a law creating an offense may provide that an offender cannot be arrested without a warrant, or that he cannot be arrested unless found committing the offense. So it's important to look at the provision. So in this regard, I would recommend that you find time to read Section 422 as well as Section 419 of the Criminal Code. Now, what then do we need to know in relation to issuance of warrant of arrest? The first thing I want to state here is that a warrant of arrest is issued, as I have mentioned, following a complaint. And please look at Section 23 of the CPA. Also, Ikone versus COP 1986 gives us more information about this particular issue. Secondly, the warrant must be in writing and shall bear the name, the date of the issue. It shall also contain the necessary particulars, and it shall be actually signed by either the judge or the magistrate that is issuing it. Remember the point that we also read earlier on in terms of warrants and seizures, so you can understand. But please find time to look at Section 22 Sub 1 of the CPA, as well as Section 56 Sub 1 of the CPC. The third point I want to make is that it must also state the person to whom it is directed to and who shall execute it. That is contained in Section 25 Sub 1 of the CPA and Section 58 Sub 1 of the CPC. Furthermore, warrant of arrest can be endorsed with bail indicating the conditions for bail. Example, that you need, they may state that you need sureties. It may state the amount by which the sureties and accused are to be bound. You know, it may also state the court before which the person is to attend and the time at which he or she is to attend that. Okay, please look at specifically Section 30 of the CPA. Look at also at Section 57 of the CPC, as well as the Administration of Criminal Justice Act 2015, specifically Part 3. Now, bail cannot be granted if offense is punishable with death. Only High Court can actually grant bail in such offenses, and that is in terms of exceptional cases. Look at Section 29 of the CPA and Section 60 of the CPC. The warrant must be shown to the person being arrested before execution of arrest, unless there are good reasons to the contrary. If the warrant is not immediately available, for example, its existence must be disclosed and it must be shown to the arrested person as soon as possible. Please look at section 29 of the CPA and section 60 again of the CPC. The other point I want to just mention very briefly here is what is the life of a warrant? It remains in force until it is executed or it is cancelled by the judge or the magistrate that have issued it or that is of the same rank. Look at section 25 sub 2 of the CPA and section 56 sub 2 of the CPC. Okay? Now the other point is, what of the issue about court discretion in relation to issuance of arrest warrants? The court indeed have the discretion in deciding whether to issue summons to appear or warrant of arrest. I want to repeat the point I have made here now. The court has a discretion to decide whether to issue a summon to appear or to issue a warrant of arrest. Both of it cannot be issued on the same person. So, in other words, if a summon is issued, it's like the court is saying, please, you should appear in the court on so date on so date. So you let the person will come from their home or from whatever place they want, but at their own time, and they're not going to be forced to. They are going to come willingly to the court. However, in relation to warrant of arrest, it means that the person needs to be detained and put in custody and then be taken to the court by the police or any other law enforcement agency. So it may even reject the complaint totally. So for example, apart from the court being able to say we will decide to issue someone to appear or we will decide to issue warrant of arrest, you can make a complaint and the court will dismiss it, meaning they will not even grant the warrant of arrest. Now, section 81 sub 1 of the CPA and section 154 sub 1 of the CPC is somewhere I really would like you to find time to read very well. The court must state the reason for the refusal whenever the court decides to refuse the complaint or to treat the complaint. Now, note, court can issue process even when it lacks the jurisdiction to try such offense, provided there is a competent court within the state to try that offense. Okay? But this is a practice that we all don't like, the practice of holding charge. We don't really want that to be continued. So, look at section 79 of the CPA and section 139 of the CPC. Now, someone to appear and a warrant of arrest may be issued or served on any day, including on Sunday or public holiday, and at any time and in any part of the state. Look at section 28 sub 2 of the CPA. Also, the death of a magistrate or that the magistrate is in vacation or is retired or is removed will not invalidate a summon that had been issued by that magistrate. Manner of service is another point I want us to discuss. Someone should be served personally on the person that is summoned. If it's a partnership, one of the partners will actually suffice. If it's a limited liability company, the director of the company or the chief agents will actually suffice. Or you leave a copy in their principal place of business or give to anyone having control at the time of service. Look at section 87 of the CPA, as well as section 49 sub 1 of the CPC. Now, the issue of substituted service. This is resorted to where ordinary service is impracticable. It may be done by either leaving the copy of the summon with an adult male member of the accused family. Section 52 of the CPC is something I would also want you to look at. In the southern states, a copy of the summon should be affixed to, actually affixed into a very conspicuous part of the premises, and this will actually do the premises in which the accused ordinarily resides. So the accused must ordinarily reside in such premises. Look at also section 90 of the CPA. The mode this particular mode of service is actually permitted. In the North, also the process server must endorse a copy of the summon. However, before recourse to substitute service, the leave of the court must be obtained. So if it is impracticable to serve the person, other alternatives can be used. But please, this needs to be, actually, the leave must be gotten of the court in terms of this, to be able to apply substitute service. Public summon. Let's look at public summon. This is available only under the CPC and can only be issued by a judge of the High Court if he has reason to believe that a person summoned has actually absconded. He may publish that the person appear at a specified date and time and to appear not less than 30 days after such publication. Now, look at section 67 sub 1 of the CPC. The mode of publishing is such that it will be publicly read. It shall be affixed in a conspicuous part of the house the accused resides or conspicuously placed in the town. A copy shall also be affixed in a conspicuous part of the High Court. So the High Court, the person's premises, where the person normally resides, or any other place, this can also be done. Please look at section 67 sub 3 of the CPC, 67 sub 3. Now, mode of receipt. The person served must acknowledge receipt by signing the duplicate. Okay? See section 94 of the CPA and section 40 sub 2 of the CPC. Where a person refuses to sign such duplicates, he may be detained or committed to custodial center for 14 days in stated prison. And that is, look at section 95 of the CPA. Section 95 of the CPA. Now, service and execution of warrants of arrest outside the state of issue is also another point I would like you to look at. In this regard, please find time to refer to section 92 of the CPA and section 54 of the CPC. Okay? Now, and then you will see the details there, what it has been said. So I'll give you just a few of them. To effect the service of a summon in another jurisdiction outside the issuing court's jurisdiction, the summon shall be sent in duplicate to a court in whose jurisdiction the accused is resident. That court shall therefore direct service as if it had issued the summon. See section 92 of the CPA and section 54 of the CPC. Okay? So, notwithstanding the term jurisdiction as used here, it implies that both courts are within same state. Also, I would like you to find time to look at section 7 of the CPC. Okay? It talks, and also section 482 and 484 of the CPA, in relation to interstate service, which has nationwide application. The procedure is the same both in the north and in the south of Nigeria. I think we need to note that. The warrant will be taken to the appropriate magistrate in the state where the accused resides, who will certify himself that the warrant is issued by the magistrate or judge whose name appears on the process. Okay? Let's look at another point. And please find time to read all the sessions I'm giving you reference. So that way you are enriching your knowledge a little bit much more around this. So when effecting arrest with a warrant, there are some guidelines it's good that you need to look at. One of them is we talk about the need for you to identify yourself. We have said that before. Second thing is that we need for you to present the warrant of arrest. And then, if requested, allow the arrested person to be accompanied by their family members or their relative or their friends from the place of arrest to the police station or the headquarters, where the said arrested person would be processed and detained. Okay? As much as possible, members of our arresting team should be in their complete uniform. We cannot overemphasize this. We've talked more about the uniform issue. We've talked about the issue of vehicle. This is really important. Okay? Arrest without warrant. The law defines those who may arrest without warrants. One is either the police can do that, the judge or the magistrate, and also a private person. Now, for the police, when the person commits an offense in the presence of the police officer, and also when the police suspect a person to have committed an indictable offense, or when the offender refuses to give his or her name or address. Okay? The second issue is the magistrate or the judge can also arrest without warrants. In this regard, please look at section 29 sub 1 and section 30 sub 1 of CPC, as well as section 15 of CPA. Remember, again, the third person who can arrest is a private person. Now, I think you need to look at some of the sections that I have mentioned. I've mentioned that before. Let's go back to the point we were discussing. What I would like you to do is take time to read section 26 of the CPC. Also read section 10 sub 1B of the CPA. Look at also section 10 sub 2 of the CPA. Now, and then look at section 26E of the CPC and section 55 of the CPA. When you take your time and read some of these things, and then you look at some of the processes that currently you are undertaking, and then begin to identify what these rules are and how you need to comply with them. But understand that the discretion of the police to arrest without warrant must be based on good faith. This is known as the Udhr principle. Okay, and this actually is derived from the case, the Associate Providential Picture House versus Westbrook Corporation. This is a very old case, 1948. So if you must arrest without warrant, you must do it in good faith. That's just the key point, okay? So let's move on to look at other things. There are situations where a person can arrest without warrant, but a private person can arrest without warrant. But what are those situations? These include if a person in his view commits an indictable offense, or if he reasonably suspects a person to have committed a felony, or if he reasonably suspects a person to have committed a demeanor by night. Then also when a person is found committing an offense involving injury to a property by the owner of the property or his servant or a person authorized by him. With respect to this last point, look at section 13 of the CPA. Okay. Note also, anyone arrested without warrant should be handed to the police timeously. So even though a private person can arrest without warrant, but as soon as you do that, the person must hand over that arrested person to the police timeously. Look at how this is provided for under section 9 of the CPA, section 14 sub 8 and 2 of the CPA, as well as section 39 sub 1 of the CPC. Please, I hope you are taking time to go through that we are recommending and are mentioned here, because that is the only way you can deepen your knowledge on these issues. Now, there are still some further things I want to mention in terms of the guideline for the police when they are effecting arrest without a warrant. So when a person has committed or is actually committing or attempting to commit an offense or crime in the presence of a police officer, then you as an officer, you can arrest the person, okay, without warrant. When an offense or crime has just been committed and the police officer has personal knowledge of facts relating to this, so personal knowledge relating to the person who have done it, what the person have done and all that, and the fact that what has been committed is a crime, you can arrest the person. Also, when the person to be arrested is an escapee, he has just escaped detention, you can arrest the person without warrant. Also, when the person arrested without warrant is immediately brought to the nearest police station, he or she should be subjected to the provisions of both the CPA and the CPC. So when you do that, when you arrest without warrant, every other process keys in that are lawful, the procedure must also be killed in. And it's been clear the circumstances where you as a police officer can arrest without warrant. Now, an arrest without warrant is considered unauthorized and illegal if the warrant of arrest is made due to mere suspicion of belief or unsupported by facts or supported by credible information or by circumstances necessary to necessitate that clause. So it's actually saying it is not right when you do arrest without warrant in bad faith. So please do not do it. Okay? Now, remember as officers, you must promote and protect the rights of the citizens. You must follow due process. You must recognize the presumption of innocence. Everyone is deemed innocent until proven otherwise. You must also recognize that we are all equal before the law. So if there's any reason why you need to violate or restrict anybody's right, it must be in those ways that have been conceived and determined and indicated even in law. And our Constitution has actually clearly shown us what should be done and what not to be done. So please, when you go out in the field there, it's expected that you comply with all this. Thank you again for signing on to this training.